Your Honour, if it pleases the court, my name is Frank Frank, initials GM. I am before your honours today representing the accused, Mr. Sonny Barger, who is charged with an alleged breach of Section 233 of the Code for possession of a thing used to play an unlawful game. Conferred upon us by Section 590, A, subsection 2E of the Criminal Code, we apply to the courts to rule my client's backpack and its contents inadmissible. The backpack and its contents are vital to the Crown's ability to prove beyond a reasonable doubt that my client did have unlawful gaming equipment in his possession. Applying the reasoning in Goldsmith and Sanderline, this piece of evidence could rationally affect the assessment of probability of the existence of the main fact in issue. Prima facie, this makes this evidence admissible. We, however, seek a ruling for your honour to use their judicial discretion to exclude the evidence on the basis of public policy, that is the Ireland discretion. As examined in Bunnings and Cross, your honour can exclude evidence that has been unlawfully or at least improperly obtained at your honour's discretion. The defence contends that the backpack and its contents were illegally obtained by Constable Hunter Tamsin. Following the authority of Aaron Wilkinson, we have the onus of proving that the items were illegally discovered. Akin to Wilkinson, it is being put to your honour that the illegality of the search stems from a lack of justification to search the vehicle without a warrant. Conferred upon him by Section 31 of the Police Powers and Responsibilities Act, Constable Hunter Tamsin initially had a supposed right to search the vehicle without a warrant. A prescribed circumstance for searching a vehicle without a warrant is if a police officer reasonably suspects that a passenger of the vehicle has committed or is committing an offence against Section 10C of the Summary Offences Act. On the constable's initial perceptions of my client's attire whilst on the footpath, my client may have appeared to be committing an offence pursuant to 10C. Section 10C prohibits a person to wear, visibly, a prohibited item in a vehicle that is in a public place. Sonny's black polo from the footpath may have appeared to have buzzards and 1% embroidered on the badge, satisfying the Liquor Act's definition of an identified organisation. Consequently, this would have constituted a prohibited item under 10C. Sonny, however, at the time of the offence, was wearing a black polo with the phrase buzzcocks and the words 1%. The fabric on the shirt therefore did not constitute a prohibited item for the purpose of 10C. The Crown may argue, nevertheless, that Constable Tamsin had reasonable suspicion that Sonny was wearing a prohibited item. This submission should be rejected by your honour, as before the constable searched the car, my client made it very clear that his attire was not prohibited. Furthermore, when Tamsin was conversing with my client, the constable would have been close enough to observe that the phrase on the shirt was in fact not prohibited. It would therefore have been abundantly clear to the constable at the time of the search that my client was not wearing a prohibited item. Prima facie, this would make the searching of the vehicle without a warrant outside the ambit of Section 31 of the PPRA. Assuming that your honour accepts the fact that Constable Tamsin did not have lawful grounds to search the vehicle due to my client not wearing a prohibited item at the time of the search, the Crown will argue the power was nevertheless provided due to Sonny's past convictions under 10C. These are not in dispute. Regardless of which argument the Crown proposes, either his perceived commission of 10C or past convictions, the backpack was not searched for anything relevant to why my client was being detained. Constable Tamsin, pursuant to Section 31, only had the power to search the vehicle and anything in it for anything relevant to the circumstances for which the vehicle and the occupant were being detained. The constable informed my client the reason for the search was that Sonny was wearing a prohibited item at the time of the search. The power therefore conferred upon the constable was to search for anything relevant to the contravention of 10C. If, for example, the bag had 1% or buzzards plastered all over it, then perhaps that would be justification to search the contents of the bag. This, however, was not the case. The black nylon bag and the two-up implement were not relevant to the commission of an offence pursuant to 10C. It is therefore our submission that the constable did not have lawful authority to search or to confiscate the items from my client. Your honour may be concerned with, per Justice Stevens in Bunnings and Cross, society's right to insist that those who enforce the law themselves respect it. Bunnings and Cross provided 5 factors that your honour ought to consider when determining the application of the discretion. Constable Tamsin was made aware that my client was not wearing a prohibited item before the search was conducted. It cannot therefore be reasonably said that the breach of law was a genuine mistake. Constable Tansen, as an informed member of the police force, would have known that the search was conducted without lawful authority. Due to the perceived lack of mistake, the cogency of the evidence against my client need not be considered by Your Honour. Furthermore, this was not a genuine response to pressing circumstances. There were no grounds for a reasonable suspicion that my client would dispose of the bag and its contents. My client was told that he was being searched because he was wearing a prohibited item. There was no reason for Sonny to suspect that he would be charged with an offence pursuant to Section 233 of the Code. Acknowledging that the provision of justice is ultimately at Your Honour's discretion, we bring these questions of admissibility to Your Honour's court and await further instructions. Thank you, Your Honour.